Your Lordship, I would like to mention item number 4, 5, and 6 from Part B. May it be kindly listed.
Item number of which list?
Part B.
Part 2.
Part 2, yes.
Yes.
4, 5, and 6 item.
Four, 5, and 6. Okay. For the day?
Next week, Your Lordship.
Next week?
Yes.
All right, next week. Okay. Oh, list in the next week on the prayer of counsel for the petitioner. Appellant.
Daily list for motion, item 1.
Please, Your Lordship. This is contempt petition filed by the petitioner for non-compliance of the order dated 5/8/2024, passed by this Honorable Court in WPC number 53 of 2024, wherein the state respondents were directed to consider the case of the petitioners for granting the benefit of county deposit service rendered by them on ad hoc basis for their placement to the senior grade and selection grade in terms of the notification dated 19/7/2013 within a period of 3 months from the date of receipt of the certified copy of the order. And
No affidavit has been filed by the contemnors?
no
Affidavit in opposition, huh? This is the first time. Okay, this is for motion. Fine. I think similar matters were already moved earlier.
Yes, Your Lordship. Similar matter in WPC number 52 of 2022, wherein this writ petition was disposed in line with the 52 of 2022. The petitioner therein, they have considered their cases that I have annexed in the annexatory.
Okay. Contempt notice, usual order. How long do you give? 4 weeks. All right. 4 weeks notice. You are taking steps by registered post.
Yes.
Item 2.
May it please Your Lordship. My Lord, here is a case, my Lord, where 2 FIRs, my Lord, have been filed on the same set of facts, my Lord. And, my Lord, if Your Lordship will see the first FIR, my Lord, which is at page number 29. My Lord, the type copy is at page 29A, my Lord.
Yes.
29A, my Lord. I'll read, my Lord. We, Mahindra and Mahindra Finance Services Limited Company, are a company incorporated under the Companies Act 1956, having CINL so-and-so and registered as non-banking financial company NBFC with Reserve Bank of India and having its registered office at Gateway Building, Apollo, Bundar, Mumbai, for so-and-so. And corporate office is at so-and-so, my Lord. First, companies engaged inter alia in the business of advancing loans, finances for the purpose of purchase of motor vehicles, SME finance, leasing of vehicles, etc. 2. During our routine verification, we asked our area business manager, Mr. Jakir Habibur Hussain, mobile phone number so-and-so, who had sanctioned below mentioned loan accounts which were processed through his subordinates, Mr. Joseph V. L. Choimoya, Vanlal Thanaralte, and Mr. Redenthara. My Lord, I am appearing for Mr. Redenthara in this case, my Lord, to submit B extract of registration certificate of vehicles in question. But to our surprise, all PDF copies provided by Mr. Jakir Habibur Hussain shows some QR code with different number. Certificates submitted by Mr. Jakir Habibur Hussain appears to be fake. Further, we suspect that our employee is colluded with dealer of the car dealership and his representatives, the borrowers and guarantors, as well as some unknown accused have cheated our organization. Due to these actions, the company does not have any security hypothecated vehicles under these contracts. People have misrepresented with the help of forged RTO records to avail loan from Mahindra Finance. The amount financed by Mahindra Finance in these 9 cases is rupees 63,23,000. We are apprehensive that these 9 cases are just the tip of the iceberg, and we apprehend that this is just a small part of a big pre-planned fraud committed by our above stated employees with help of others to cause wrongful loss to the organization and to get wrongful gain for themselves. We have started our in-house investigation on the overall life portfolio done under Zakir Hussain, Habibur Hussain. There are more than 600 cases which have been done under him. We have come to know from relevant sources that Zakir Habibur Hussain has come to know about the internal investigation which is happening against him and will try to flee from the local jurisdiction of the local court. Thus request you to investigate the case in the interest of justice and equity. Now, my lord, some investigation was done pursuant to this FIR, my lord. And if your lordship will kindly turn to page number 389, my lord. So this next document which I am showing to your lordship, my lord, was issued 9 days after this FIR was registered, my lord. And in lordship 389, my lord. This is the last page, my lord. My lord has got it.
Yes, 389.
389, my lord. I'll read, my lord. This is an order issued by the IGP of Mizoram Aizawl, my lord. It says like this: investigation of Aizawl Police Station FIR number 96 of 2024. This is the FIR, my lord, I had read out. Dated 23/2024 under section 408, 467, 468, 34 IPC has been transferred to Crime and Economic Offences Police Station for further investigation. A special investigation team comprising of the following officers is hereby constituted with immediate effect. And then 10 names have been listed. And below, my lord, the special investigation team shall conduct investigation meticulously and submit progress of the case through guard file. To the undersigned, SPCID Crime will supervise the day-to-day investigation of the case. Now the next page, my lord, for 390, there was a small modification to this previous order. I'll not read out, my lord. Basically, it's off to the same effect. Now, my lord, thereafter, what happened was this FIR I had read out, my lord, was transferred to the Crime and Economic Offences. On the same day when this case was transferred, my lord, another FIR was submitted in the Crime and Economic Offences, my lord, which is at page number 36, my lord. And this second FIR is, my lord, is the subject of challenge in this case. Page number 36, my lord. My lord has got it. My lord, I'll read out. I, Chanpreet Singh, son of S.P. Singh, business head at Mahindra and Mahindra Finance Services Limited, Mumbai, brings to your kind attention as under. I am working as business head with Mahindra and Mahindra Finance Services Limited, which is a non-banking finance company engaged in the business of advancing loans, finance for the purpose of purchase of motor vehicles, SME finance, leasing of vehicle, etc. During our routine verification, we have come across a large-scale fraud and forgery committed by our business manager, Mr. Zakir Habibur Hussain, in sanctioning many vehicle loans at our Aizawl branch. The broader scrutiny of the records of the branch in the aftermath of the serious fraud committed by the branch manager, Zakir, and his co-conspirators, I have discovered that my official identity has been impersonated by Mr. Zakir Habibur Hussain and his co-conspirators, H. Lal Thankima, mobile phone number so-and-so, and Adanthara, have created a fake entity that is Mahindra Finance Limited with a similar description as of my company and executed fraudulent transactions, including in cash, in crores through this fake entity set up through his co-conspirators. The details of the said fake accounts are as follows, and the details are given now, my lord. I'll come to paragraph 4. I would like to inform you that I had never opened or operated the above account, and the same has been opened and operated by above mentioned accused persons with the aid and assistance of employees of MMFSL Aizawl branch as joint signatory, namely H. Lal Thankima, office boy, and Adanthara, our business executive. The said fake account has been used by the above named accused persons as a means to defraud the company and misuse finance amount that were to have effect to and from dealers. In turn, the dealers were also parking the unauthorized amount and projecting it as an untainted account of MMFSL. In order to open the said account, the accused persons have prepared forged identification document of company resembles to MMFSL, forged seal of business head and collection in charge, forged PAN number, forged incorporation documents of dummy company Mahindra Finance Limited, forged company seal, etc., and represented themselves as unauthorized persons of MMFSL and a common object to gain undue advantage and defraud the MMFSL and public at large. A bare perusal of the account statement of the said fake account reveals that there are transactions of more than rupees 80 crore in the said account within a short span of nearly 3 years. The said act prima facie indicates the commission of offense of forgery and identity theft. The offense punishable under section 419, 463, 464, 466, 467, 468, 469, 470, 471, 472, 474, 477A, 120B, read with section 34 of IPCR prima facie made out against Mr. Zakir Habibur Hussain, H. Lat Hankima, and Adenthara, that's my client, and other unknown conspirators and accused persons. The said act of accused persons and new dimensions to the scam committed by them, the documents discovered by us are enclosed for appropriate legal action for registration of FIR and consequential speedy actions against the fraudulent offenders. Now, my lord, investigation was done on the basis of these two FIRs, my lord. And the investigation, my lord, reports have been submitted in court.
No, why do you say that this is a second FIR? Has any separate case been registered on the basis of this FIR?
Yes.
This
It has been done, my lord.
two cases.
Two cases have been registered. In fact, my lord, if your lordship will come to page number 41. My lord has seen page number 41, my lord.
Yes.
There, my lord will see on the top it says CID crime Isol PS, the FIR number 96 of 2024. My lord has seen it.
Yes.
So that is the name of the number of the first FIR, my lord. And your lordship will see at serial number 8, T. Zarzoliana, my lord, the investigating officer. The same investigating officer, my lord, has also investigated for the same FIR. Second FIR, sorry, my lord. And the second FIR, my lord, is at page number 205, my lord.
Second charge sheet.
Second charge sheet, my lord. Second charge sheet 205. And the second charge sheet, my lord, the top, the number is there. It says PS CNEO. Your 2024 FIR number 3 of 2024. Investigating officer serial number 8, my lord. Again the same. And if your lordship would, I am not going to take your lordship at this stage. I'll not trouble your lordship now, my lord. But if we were to go through the charge, the investigation report with respect to my client, my lord, in the two charge sheets, my lord, they are identical, my lord. Word by word, they are identical. And in fact, if your lordship will see something very unusual, my lord, if your lordship will come to page number 315, this is another charge sheet. There are two supplementary charge sheets submitted in these two FIRs, my lord, in these two charge sheets. 315, my lord. Your lordship will see the serial number and number 1 property descriptions.
Yes.
There your lordship will see certified copies of seizure memo dated 24/7/2024 in CWPS case number 96 of 2024. So what they have done, investigating officer, my lord, is simply relying on the seized document, my lord, used for seizure in the first FIR. And it is on this basis, my lord, these two criminal cases have been submitted in the court, my lord, these two final reports. And in fact, your lordship will come to page number 369. Presently, my lord, let me tell your lordship that there are 7 cases of a similar nature like this, my lord, which are pending before this honorable court. And the order in the first case, my lord, which is criminal petition number 19 of 2024, my lord, is at page number 369. And we are basically, my lord, coming into this court, asking for this court to allow us to argue in this set of cases, my lord, by filing this case. My lord, page number 369. My Lord, we'll see. I'll read from paragraph number 2 because the facts are identical, my Lord, in this case. Page number 2, serial number 2. This petition under section 528 of the Bharatiya Nagarik Suraksha Sanhati BNSS 2023, section 482 of the CRPC is preferred by the petitioner, namely Yogesh Sarda, for quashing the FIR and all proceedings emanating therefore, including the charge sheet of the case registered as crime and economic offences, Aizol PS case number 3 of 2024. We are challenging the same FIR, my Lord. It is to be noted here that an FIR was lodged by one Ankit Bakri, unauthorized signatory for Mahindra and Mahindra Financial Services Limited Company for short, on 23/2024, which was registered as Aizol PS case number 96 of 2024. The essence of allegation made in the aforesaid FIR dated 23/2024 is that Mahindra and Mahindra Finance Services Limited Company is a non-banking financial company, NBFC, and engaged in the business of advancing loans, finances for the purpose of purchase of motor vehicles, SME finance, leasing of vehicles, etc. During their routine verification, they asked their area business manager, Mr. Jakir Habibur Hussain, who had sanctioned loan accounts which were processed through his subordinates, Mr. Joseph Vielzoy Moya, Vanal Thanaralte, and Mr. Eden Thara, to submit B extract of registration certificate of vehicles in Aizol. But to their surprise, all the PDF copies provided by Mr. Jakir Habibur Hussain showed some QR code with different numbers, and the certificate submitted by Mr. Jakir Habibur Hussain appeared to be fake. Further, they suspected that their employees colluded with dealer of the car dealership and in his representatives, the borrowers and guarantors, as well as some unknown persons, cheated their organization, for which the company did not have any security, hypothecated vehicles under these contracts, and people have misrepresented with the help of forged RTO records to avail loan from Mahindra Finance, and the amount financed by Mahindra Finance in these 9 cases was rupees 62,23,000, which may be the tip of the iceberg, as they apprehend that it is a big pre-planned fraud committed by their employees with the help of others to cause wrongful loss to the organization and to get wrongful gain for themselves in their investigation. They found that on the overall life portfolio done under Mr. Jakir Habibur Hussain, there are more than 600 cases. Mr. Pukan, learned counsel for the petition, submits so and so, my Lord. I'll not read all of those things, my Lord. And in this case, my Lord,
So it is already stayed in an earlier.
yes, and notice has
case.
been issued, my Lord. So in this case, my Lord, what we are praying at this stage, my Lord, is that let notice also be issued in our case, and let this matter be taken up along with these 7 other cases, my Lord.
Heard, Mr. Yuvar,
Joseph Elrentley, my Lord.
for the petitioner, and you're appearing for respondents.
Yes, Your Lordship, for the state respondents.
For the state respondents, where is the criminal petition? Also, where is the order dated 01/08/2024, passed by this court in criminal petition number 19/2024. Annexed to the present petition. Issue notice to the respondents number. Give the name of the private respondents.
2 and 3, my
2
Lord.
and 3. Steps back, registered, posted in 3 days. These other matters are listed,
They are listed on 4th September, my Lord.
list on 4th of September, along with
Criminal petition number 19 of 24, 1 of 25, 7 of 25, 8 of 25, 11 of 25, 14 of 25, and 26 of 25. Much obliged, my Lord.
For admission, item 3.
May it please Your Lordship. In respect of this item number 3 to 9, they are all arising out of the one common judgment in order, and the state has preferred an SLP before the apex court, and it's pending as on date. And there is an interim order of stay, as can be seen from the last court order dated 8/5/2025.
so this contempt is, as of now, what?
We'll have to await the outcome of the SLP, Your Lordship. So in the meantime, Your Lordship, my humble prayer is that let it be taken up again after 6 weeks, So in the meantime, if any new order is there in the SLP, I'll place it before this honorable court.
All right. Heard Mr. Sensor, counsel for the petitioner. Mr. appears for the.
Respondent number 4.
It is submitted on behalf of the petitioner that the state has preferred an SLP before the Honorable Supreme Court, challenging the order dated, which one?
29/11/2024.
In WPC,
Writ appeal, Your Lordship.
writ appeal, okay, writ appeal so and so. Give the number, okay.
Yes, Your Lordship.
In respect of which the present contempt petition has arisen, and that the Honorable Supreme Court has also passed an interim order of stay of the impugned judgment and order. Hence, list the matter after 6 weeks. Learned counsel for the petitioner shall apprise the court if any subsequent order is passed by the Honorable Supreme Court.
My Lord. Similar judgment up to 9, Your Lordship.
Up to 9.
Deeply obliged.
Item 10.
May I please, Your Lordship? In this regard, service report, Erica has returned in respect of respondent number 3 only. So 1, 2, and 4 is still awaited.
Who are awaited?
Only 3.
Only 3.
Only 3.
Chief executive member, you can't find him. What? What will you do? Will you take fresh steps or will you wait?
I'll wait for some time.
I'll learn it counsel for the petitioner. Steps. Service on respondent number 1, 2 and 4 are complete.
No, not
No.
yet completed.
Not yet completed. 3 is served.
3 is completed.
Respondent number 3 has been served. Await service report. List after 4 weeks.
4 weeks. God bless.
Item 11 for orders.
My Lord, this is a criminal petition filed by the state, and notice upon the respondent 1 and 3 is complete. 2 is still awaited. If I may be granted some more time, my Lord.
In the meantime, my Lord, I may be allowed to submit my counter affidavit with respect to respondent number 1 and 3.
Heard learned counsel for the petitioner and learned counsel for respondent number
1 and 3.
1 and 3. Respondent number 2 is yet to be served.
Yes, ma'am.
Await service. List after 4 weeks. In the meantime, respondent number 1 and 3 may file their counter affidavits. List after 4 weeks.
Obliged.
Item 12.
Your Lordship, this IA is for suspension of the sentence while pending the appeal and to release the petitioner on bail, my Lord. The criminal appeal is pending and paper book is ready, and although it is for hearing, my Lord, we are moving this application at this stage. And one of the reasons is that, Your Lordship, now the petitioner is pregnant, and she was also suggested from jail that she could be given medical care at outside jail.
Only 1 year.
Yes, my Lord.
Then why didn't the court below suspend the sentence at that time?
No, my Lord, if I may take Your Lordship to page 46, my Lord, there is an urgency also regarding health condition.
No, that I understand, but since it is a sentence of 1 year, I think learned court below could itself have suspended it. Where is the impugned order?
Impugned order is, my Lord, in the appeal, paper book is there. If your lordship finds the paper book, my lord. The impugned judgment is page 39 of the paper book.
I think it is here. You have annexed page 20. I think this is one.
Uh,
Your page 20, is that not the judgment?
yes, my lord. 20 of the
Appeal memo or the IA?
IA. Yes, my lord. This is the judgment. Page 24 is the relevant part.
Already heard learned counsel for the petitioner and learned prosecutor peruse the impugned judgment and order. Dated 11/3/25, passed by the learned session judge Lunglei, sentencing the appellant to undergo SI for 1 year and to pay a fine of rupees 3,000 ID SI for 10 days para, having regard to the material on record. The impugned sentence is suspended pending disposal of the appeal. IA stands disposed of. Appeal is at what stage now?
Appeal is at the stage of hearing, my lord.
It is admitted.
Admitted, my lord. So my prayer is that
List the appeal for hearing.
I may be allowed to go on bail also, my lord, after suspension.
Once it is suspended, apply for bail. We want a mention.
Yes, my lord, please. Otherwise, they might be confused.
The applicant oblique appellant, so and so give the name. C. Lal Nun Moy is allowed to go on bail of rupees 20,000 with 2 sureties of like amount to the satisfaction of the learned session judge Lunglei.
Highly obliged, my lord.
Supplementary list, item 13 for admission.
Please, Your Lordship. My Lord, for the respondents, and I'm seeking some more time to file my additional affidavit.
You are for respondent?
I'm for all the respondents, 1 to 3.
What affidavit they have? I think you have filed your affidavits, 1, 2, 3. What is this? This is an affidavit. I am seeing an affidavit in reply
Yes, my Lord.
of the petitioner to the affidavit in opposition filed by the respondents 1, 2, 3.
Yes, my Lord. We are yet to get an instruction and to file our affidavit, additional affidavit, according to the last court date, my Lord.
So, petition then. Affidavit in opposition. So now you want to file additional affidavit after they have filed their reply.
Yes, my lord. The court has instructed us to make a query on regarding the computation of the research score of the petitioner, my lord. So, on the basis of that, we are to file our additional affidavit.
Yes. Heard learned counsel for the petitioner. Learned counsel for the respondents prays for further time to submit the additional affidavit pursuant to the order dated 23/06/25 passed by this court. Prayer is allowed and further 2 weeks time is granted to the respondents to file their additional affidavit. List the matter after 2 weeks.
Much obliged.
Item 14.
Lordship, I'm appearing on behalf of my senior CGC for respondent number 1. Lordship, may I seek another 3 weeks time for filing counter affidavit?
You are appearing for which one?
Respondent number 1.
Only one.
Yes, my lord.
Lordship, I'm appearing for respondent number 7 and 8. And I have
So you have filed your counter already?
Yes, my lord.
All right. Heard learned counsel for the petitioner. The respondents number 2 to 8 have already filed their counter affidavit.
Lordship, respondent number 6 is not represented.
6 is not represented.
Yes, my lord. Kala Champara.
Okay, then say excluding respondent number 6. While they, what about 6 then?
service complete, Lord Chief.
6 is served or not?
Service, yes, sir, service was completed, sir.
Completed?
Yes, sir.
Please respondent number 6.
As per the correspondence file, notice was issued to respondent number 6, that is the Kala, competent authority for land acquisition, on 58, 2024. But there is no return of ID card as per the correspondence file. There is no correspondence, there is no ID cards in respect of respondent number 6. The Lordship may have to announce the previous orders.
There is no mention of respondent number 6 in the previous orders. Land acquisition officer is not represented by government advocate. Kala? No. Okay. Any central government council is here?
Lordship, I'm appearing on behalf of my
Huh?
senior, yes, Central Government Council.
Who?
Zairem Sangpui.
He's a central government council.
Yes, my lord.
He'll represent 6. No.
No,
You?
only one.
Only one. Okay. Matter relating to compensation.
Yes, Your Lordship.
Hmm? So respondent number 6 is one of the most vital respondents, is he not? We have not received back the AD cards. So it is better to wait on the next date. We can see if central government council will represent. Service on respondent number 6 not yet complete. Average service list after 4 weeks.
Since the notice was issued way back on August of last year.
So take fresh steps. Petitioner to take fresh steps within 3 days. Registered AD. You take steps because that was 1 year back, earlier steps. They will have misplaced it even if received.
Yes, Your Lordship.
Item 16.
Lordship, I'm appearing on behalf of respondent number 1.
Okay, we'll record that. Huh?
Lordship, I am appearing on behalf of state respondents 2 to 5. I will be
Note it. Okay.
filing my affidavit in opposition within 3 weeks.
Yes, you can do that. Since we have anyway, we are awaiting. That need not be mentioned. You can file it if you haven't.
Yes, ma'am.
No need to mention. They can file. Yes, this.
Yes, I'm for the petitioner.
Yes.
So none of the respondent has filed affidavit.
Also, you are submitting in this case. I thought you were continuing with the earlier one. Because same set of lawyers you are standing before me. That is why I thought you were on the last case. So what is this for now?
Admission.
So you want more time to file affidavit?
Yes, my lord.
Okay. This is matter of 25, all right. Hard learned counsel for the petitioner. So and so appears for respondents number
1.
1 and
2 to 5.
Mrs. So and for 2 to 5. Further time is sought on behalf of the respondents to file counter affidavit. List after 4 weeks. respondents to file counter affidavit in the meantime.
Much obliged.
Item 17 for orders.
My Lord, I am appearing on behalf of my senior Mr. Jodial Tauchong, counsel for the appealant in this matter. And as per instruction, my Lord, we have received the paper book. We have received the paper book.
You have?
Yes, my Lord. On 6/8/2025.
So we list it for admission then?
Yes, Your Lordship.
Lordship already admitted.
Already admitted?
Yes.
Okay. Then fixed for
It was
hearing?
submitted. Yes, my Lord.
Okay. It is submitted on behalf of the petitioner that paper book has been for the appellant. That paper book is ready and already received. Hence, list the matter for hearing after 4 weeks.
Much obliged.
Item 19.
Yeah, please, Your Lordship. With regard to the appeal, it is admitted, and I have also filed an affidavit regarding service of notice upon the respondent number 4 by way of Dusty. And I believe the LCR has also arrived, and but you might require, we will require a paper book. Paper book will be required, so it may be prepared.
So somebody is appearing or not? For
I'm appearing on behalf of the state respondents.
nobody for respondent number 4 as yet.
None appear.
Heard Mr. Victor L. Ralte, learned counsel for the appellant. State respondents are represented by learned government advocate. Notice on respondent number 4 has been served by Dusty Service, and affidavit in this regard has been submitted. Here is the same. Service is treated as completed upon respondent number 4. Full stop. What further order is required?
It was regarding with the appeal, paper book may be prepared.
At the cost of appellant.
At the cost of the appellant, yes.
Registry is directed to prepare paper book at the cost to be deposited by appellant. List the matter after 4
Your
weeks.
Lordship, with regard to the IA, the IA, there was an interim order earlier passed on 5/6/2025. So the interim order may be extended or continued.
IA is still pending.
Still pending.
Interim continue to
Para order of status quo passed earlier in IA number 90 of 2025 shall continue till the next date. And in the IA, you write I think IA can be disposed of, is it not? We are continuing the order in the main appeal. So, is there any necessity of continuing the IA?
The aggrieved party, the private respondent, they have not appeared.
Your Lordship, for ends of justice, the aggrieved party, respondent number 4, notice is just effective recently only, so let it be kept pending for a while, Your Lordship. Maybe they don't have the time to engage the lawyer as yet.
In view of order passed in the connected appeal, order of status quo passed earlier shall continue till the next date. List after same.
Item 20.
May I please, Your Lordship. Notice is complete upon the private respondents, my Lord.
Your Lordship, I see brief extension of 2 week time for filing counter affidavit on behalf of respondent number 1.
So in the IA you write notice on respondent number 1 has been served by Dusty Service and affidavit in this regard has been submitted. So this is on the condonation petition.
Yes, madam.
Peruse the affidavit. Service on respondent number 1 is treated as completed, but none appears for the. Anybody appearing?
Respondent number 1.
Also, you are appearing for respondent 1.
Yes.
Okay, then cut it, forget it. You don't have to write all that. Heard learned counsel for the petitioner. Mr. So-and-so, learned counsel, has entered appearance for respondent after respondent number 1. Anybody else remains? No.
2 to 6 is state, my Lord, I'll be appearing.
2 to 6. Respondent number 2 to 6 are represented. How many days delay is there?
61 days, ma'am.
61 days. So you are going to file?
Yes, Your Lordship. If I may be granted 2-week times for filing the counter affidavit. 2-week times for
2 weeks.
filing counter of
Learned counsel for
with an
respondent
objection.
number 1 prays for 2 weeks time to file objection. Prayer is allowed. Please the matter after 2 weeks.
Highly obliged.
Hearing list, item 1.
Yes.
Mr. Lordship, this is an appeal against the impugned judgment and order dated 29/6/2022. This is in connection with commission of offense under 22B of the 22B and C of the NDNPS Act. The appellant was sentenced to undergo 10 years rigorous imprisonment, and this appeal has been preferred.
Yes.
Mr. Lordship, the brief facts of the case, if I may enumerate, is that the accused was arrested on 12/10/2017 for the alleged possession of 16 bottles of Cuff Care containing codeine phosphate, 5 bottles of Cocas containing codeine, 205 tablets of Aprasil, alprazolam tablets, and 200 capsules of tramadol. And the case was registered against him, and he was charged under section 22B and 22C, and he was eventually found guilty of the commission of the offences. Now, Your Lordship, this appeal has been preferred on several grounds. Firstly, my main ground is that there were violations of section 52 and 52A of the NDNPS Act with relation to the inventory of the seized articles, drawing of samples, inventory photographs as such.
What is wrong with in the process?
In this case, if I may bring you to page number of the paper book, page number page number 49 of the paper book. 48 initially. 48 of the paper book.
Yes.
Here it says that 26.2 grams of alprazolam, 1.6 kgs of Cuff Care, and 500 grams of Cocas were seized. Now in the next page, the list of samples drawn. Out of the 26.2 grams of alprazolam which were seized, only 0.6 milligrams of samples were drawn. And out of the 16 bottles, 1 bottle of Cuff Care was taken, and out of the 5 bottles, 1 bottle of Cocas was taken. Your Lordship, this is not in compliance with the standing, at the relevant time, the standing order number 1 of 1989 was in effect. So this does not meet the criteria laid down in the standing orders, the quantity of the samples drawn. And Your Lordship, the mode of it has been stated in the charge sheet that the seized articles were kept in some plastic container, but no mention has been made in the inventory of seized articles whether there was any plastic container or any other box where the seized articles were kept. So there is contradiction in that regard also. And one more thing is, Your Lordship, the seized articles were allegedly seized on 13/10/2017. However, the seized articles were received by the FSL department only on, at page 46 it has been mentioned that it was received on 16/10, after a lapse of 3 days.
Caesar is on
13/10.
13/10/17.
16/10. 13/10/17, yes.
Yes. And
it was received by FSL on 16th and 17th, after over 3 days. And the samples were purportedly, as per page 50 of the paper book, the samples were certified by the magistrate on 13/10 also. 13/10 itself, on the same day of the...
Same day of seizure, inventory was, samples drawn and inventory was certified, is it not?
Yes, Your Lordship.
Yes.
However, the samples were were received by FSL only on 16. So there is no Malkhana register, no go-down receipt, nothing to show that the samples or the seized articles had any safe storage. So in this regard, there is possibility of tampering with the evidence, and the sanctity of the seized articles has been is brought into question. Correction, Your Lordship, one thing, the date of seizure was actually 12, and the case was registered on 13th.
Case was registered on 13.
Yes, seizure was made on 12th. Your Lordship, in this connection, if I may make cite one case which of a concurrent bench of this Honorable High Court, wherein it has been stated that I will submit the judgment later. This court is in agreement with the above observation and finds that in this instant case, the essay was seized on 13/2, and it was on the following day, that is 14/2, that PW made an application for the inventory, preparing the inventory. After comparing his essay, PW5 certified its correctness and put his signature on 14/2. However, there is no explanation as to where the essay was kept before making the inventory, and holds that the provisions of Section 55 of the NDNPS Act has not been followed.
No, what about in this case, in the evidence of the seizing officer, IO, etc., has it come out where the articles were kept after seizure?
No, Your Lordship. Usually they annex a Malkhana register or a Malkhana receipt or a go-down receipt.
No, that is the supporting evidence, but first they have to state where it was kept. Is it there? Any cross-examination on this point? No.
In the cross-examination, nothing. But in the examination in chief also, there is no mention whether the seized articles had any safe storage or not.
But your plea before the trial court is that you admitted to having possessed those articles. Your only plea is that you were carrying it on authorization from your employer. Is it not?
That was his submission at the time of cross-examination.
You did not deny even once. You gave defense evidence also. There also you said, yes, I was carrying. In 313 also you said I was carrying, but I am an employee of a pharmacy and under direction of the owner I was carrying that. That was your case in the trial?
Yes, Your Lordship.
So how do you overcome that? I understand this is about proper custody and everything is there, but once you admit that yes, these are the things.
Even after admission of possession of the alleged contraband substances, Your Lordship, it has not been proven at the time of seizure that they were actually contraband substances. It was only after examination of FSL that they were to be proven that they were contraband substances. So in this case, with lack of proper adherence to proper procedures regarding the sampling and the storage of the samples as well as the seized articles, there can be no proof that they were in fact one and the same which were seized and which were examined.
See, the questioning was very specific. 16 bottles of cough care, 5 bottles of coccus, 205 tablets of Aprocil.
Your Lordship, even if
Those were put to you, and what you said, I was working in the Gilead pharmacy.
Yes.
I therefore possessed the seized drugs.
Yes, Your Lordship,
So each and every drug you admitted that yes, I was possessing tramadol, alparil, and whatever. Is that not so?
even if that is the case, Your Lordship, what I am raising is that there is no
Any
concrete-
authority to show that even after you admitted, prosecution is bound to prove every aspect of the case?
Your Lordship, I have one citation. This case is Hanif Khan versus Central Bureau of Narcotics, 2023, 16 SEC 709, from page 711 of the judgment, para 8, Your Lordship, if I may read. No, para 7. The sample taken from the seized material was sent the very next day to forensic FSL. There are no allegations of the seal being tampered. The laboratory test confirmed that the seized material to be opium. Our attention was invited to the original Malkhana register to demonstrate that the seized sample was deposited on the very same day. In the circumstances, it was submitted that no prejudice has been caused to the appellant, even if the signatures on the seized sample had become illegible. We have considered the submissions on behalf of the parties. The prosecution under the NDNPS Act carries a reverse burden of proof with a culpable mental state of the accused. He is presumed to be guilty consequent to recovery of contraband from him, and it is for the accused to establish his innocence, unlike the normal rule of criminal jurisprudence that an accused is presumed to be innocent unless proved guilty. But what does not absolve the prosecution from establishing a prima facie case only whereafter the burden shifts to the accused. In Nur Aga, so-and-so, it was observed as follows. Sections 35 and 54 of the Act no doubt raise presumptions with regard to the culpable mental state on the part of the accused, as also place the burden of proof in this behalf on the accused. But a bare perusal of the said provision would clearly show that the presumption would operate in the trial of the accused only in the event the circumstances contained therein are fully satisfied. An initial burden exists upon the prosecution, and only when it stands satisfied would the legal burden shift. Even then, the standard of proof required for the accused to prove his innocence is not as high as that of the prosecution. Whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond reasonable doubt, but it is on preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35 of the Act, the actus reus which is possession of contraband by the accused cannot be said to have been established. Because there is a reverse burden of proof on the prosecution, the prosecution shall be put to a stricter test for compliance with statutory provisions. If at any stage the accused is able to create a reasonable doubt as part of his defense to rebut the presumption of guilt, the benefit will naturally go to him. So that is my standpoint.
All that is fine as long as you denied that anything was recovered from you. But once you say it was recovered from you, what was there for the prosecution to do?
But Your Lordship, yes, I agree that he had admitted to the possession of the alleged contraband substances, but there has been discrepancies and doubts regarding the sanctity of the seized articles and the samples which were sent due to the delay which was caused, the lack of Malkhana register, the lack of proper storage. And even the inventory photographs do not show any nexus between the seized articles and the instant case, because the sampling was also not shown to be done in the presence of the magistrate, even though the signature was put there. And no samples were shown in the inventory photograph. Only a picture of some of the seized articles were depicted in the photograph. So there is no concrete evidence, no proof beyond reasonable doubt that the seized articles were in fact kept in a stored in a safe place, that they were properly handled, samples were drawn and were sent with undue delay to the FSL laboratory so as to discard any chance of doubting the case of the prosecution. So it is my submission that in this case, there are certain lapses which have caused doubt in the case of the prosecution. And as cited in the, as mentioned in the case which I have cited, the burden of proof of proving the case beyond reasonable doubt has not been complied with in the instant case. And there is some doubt regarding the samples as well as the seized articles, which would go in favor of the accused, the appellant.
Yes. That is all?
Your Lordship, if I may cite another case. This case is Alamo. I'll just look at the name of the case. Alamo Lota.
Yes, which
Yes,
part
Your
of it?
Lordship, page 310. This court in similar case, namely so and so, on the basis of the various rulings of the apex court, observed that the court is to take note that the NDMPS Act is a special law with stringent provision for control and regulation of operation relating to narcotic drugs and psychotropic substances and illicit trafficking. The offense under the NDMPS Act therefore is always treated with serious penal provision. Due to serious penal provision provided in the Act, it is always emphasized that the procedural safeguards under the statute are followed strictly. The settled law is the more stringent the law, stricter compliance of procedure laid down in the law is needed. In the present case, I have already discussed and pointed out the manner in which the recovery, drawal of sample, packeting and sealing of the sample and sending them to FSL without strictly observing the procedure laid down under Section 55 of the NDMPS Act. The procedure adopted by the prosecution is found to be far from satisfaction of the court. The judicial conscience does not accept the procedure adopted by the prosecution in the present case. In such a situation, the court is bound to take a view that the prosecution committed serious irregularity and infirmity in the investigation of the matter. The existence of contradiction and consistency of important prosecution witnesses does not inspire confidence of the court to approve and the conviction so and so. There were several missing links in the investigation of the prosecution, and it has failed to convince the court that prosecution has been able to prove the charge against the appellants beyond reasonable doubts. That is another standpoint which is almost similar to the one which I had raised. And also, Your Lordship, one more factor is that the FSL expert was not examined in court. He was not brought before the court to prove the document which he had prepared. So, in the absence of,
Who exhibited the FSL report?
I think it was the case IO, Your Lordship.
Did you object at that time?
Your Lordship, I was not the counsel at that time.
But the record has to reflect whoever was the counsel. Did you make any prayer for summoning of the FSL expert? Because 293 CRPC permits the court to read the report of the assistant director of FSL without calling him as a witness.
And one more thing, Your Lordship, as has been mentioned in the previous case, the 2020 case, which was cited earlier. The burden of proof on the accused is that of preponderance of probability, and that on the prosecution is beyond reasonable doubt. In this case, the appellant had brought a witness stating that he was employed by Gilead Pharmacy, who was also employed by the Gilead Pharmacy at that time, saying he was working under the instructions of Gilead Pharmacy and that they used to transport such items for the said pharmacy. And he has also stated, the witness has also stated at page 13 of the paper book, page 13, paragraph number 7 of the cross-examination. It is a fact that our employer did not make any statement before the excise personnel in fear of cancelling their license, but I do not know why they fear of cancelling their license. So here also it has been clearly stated that they were acting under the instructions of their employers. And that they were not the ones who were in actual control of the seized contraband substances. They were only medical representatives at that time. So if due weightage is given to the defense evidence also, and if the case is that of preponderance of probability, there is every possibility that the accused was acting in good faith and that he had been acting only in the instruction of his employer.
Yes. What else?
Your Lordship, for now that will be it, but if I may be allowed to make a rebuttal after the submission of the, by the
Yes.
prosecution.
Prosecution.
With regards to the sample drawn, that my learned friend have said that there is violation of section 52. With this regards, Your Lordship, if I may take Your Lordship kind attention to page number 7, here the JMFC was
Examined.
examined and cross-examined, and it was duly signed in page number 50 by the said JMFC, Your Lordship, and photograph was taken. Now, Your Lordship, maybe the photograph of the JMFC is not there, but then, Your Lordship, in 2004, SCC Online SC 3848, NCB versus Kashif, in para number 24 to 32, it's explained, it has explained that the word or is there. The word or is there. Section 52, that's what Section 52A.
No, what is the point you are trying to rebut?
Your
His
Lordship,
objection is that he has raised the point that inadequate samples have been collected
first is inadequate sample is
in violation of the standing order.
in the standing order, yes. And second is that photograph is not there, a photograph of the JMFC is not there, and just that he
You
have
said that
appended
I did
his
not hear
signature.
that, is it?
He said
Only a vague submission, Your
Huh?
Lordship. Only a vague submission. But I will-
Photograph of ZMFC, okay, not required. That was different thing.
yes, photograph of JMFC is not required because the word or is there, certification is there, that is enough.
Yes.
So it's beautifully explained in that 2024 in Kasif's case.
Para?
Para 32, Your Lordship.
1-3. Huh?
3-2.
3-2. Yes, Kasif.
Your Lordship, if I started from the fourth line from the bottom, Your Lordship, in para 32, the use of the conjunction or made in between the three purposes mentioned therein itself makes it explicitly clear that the purposes for which the application could be made under subsection 2 are alternative and not cumulative in nature. So certification is there, photograph of these articles is there.
All right, you have drawn the samples in the presence of the magistrate,
Yes.
prepared inventory which has been certified by the magistrate, taken photographs,
Yes,
certified by the magistrate.
yes.
Understood. Now, what is your response to his question that inadequate samples were taken in violation of Standing Order 1089?
Yes, Your Lordship, standing order, no doubt, is not a statutory law. However, we should give, prosecution should give adherence to it if possible. But Your Lordship, not adhering to the standing order would not per se make the prosecution case vitiated, Your Lordship. And Your Lordship, with regards to my learned friend, contention that FSL personnel is not examined. Your Lordship, section 293 of CRPC have stated that the court may, at as its discretion or upon party's request, summon and examine the expert if it deems necessary for ends of justice. Your Lordship, I do not have the citation in ready. I have one citation, but then I have made the wrong citation, and I do not have my citation book today. But then in one of the, there is a PEX code authority that while focused on procedural safeguard under NDNPS Act, the code implied that forensic reports from government labs admissible under 293 do not require the expert's examination unless disputed or unclear. So it is never disputed, Your Lordship. This is not, 293 is not examination of expert, it's not a mandatory provisions which would make the prosecution case vitiated as mandatory provisions like section 42, etc. So it is the discretion.
You are quoting some judgment.
I'm not quoting any judgment because I have given the wrong citation and I forgot my citation book today. The citation that I gave is the wrong citation, but I think it's wrong in number.
Okay, you give us the citation later on. You can.
Yes, I can do that, Your Lordship. With regards to the expert examination is not crucial to the case of the prosecution. And with regards to in my humble opinion, Your Lordship, the prosecution have proved their case beyond reasonable doubt. Now, the reverse burden of proof is on the accused. Now, the accused, before adducing before the learned trial court, has failed to shown his defense, Your Lordship. In fact, he admitted to having possessed the seized articles. And second is that the employer never came to his rescue before the learned trial court. I don't think that a licensed, I don't think that a licensed employer, a licensee would let their men take out that amount of illicit articles without their supervision, etc.
All right, yes, anything in?
Storage, okay. With regards to the FSL, Your Lordship, it was, list of sample was drawn and sealed before the learned JMFC. And if I may take Your Lordship kind attention to page number 46 of the paper book.
Page?
Page 46, Your Lordship. Your Lordship, the parcel consists of 3 exhibits in the second paragraph. Modes in which parcel found to be packed in receipt of the description of seal. The parcel consisted of 3 exhibits packed in polythene bag and plastic bottles and enclosed therein in paper envelope sealed with wax seals and seal impression corresponding that to the forward. Your Lordship, this in the first paragraph, this is in connection with excise and narcotics case GR number 172 of 2017 dated so and so. This is the same case. So in this regard, if I may cite one authority, Your Lordship, 2015 6 SCC 222. Paragraph. Paragraph 38 and 39, Your Lordship. Page 246. Page 246. May I read, Your Lordship? Another submission that has been advanced by the learned counsel for the appellant is that the seized articles were not sent immediately for chemical examination. The FSL report dated so and so states that the letter along with the sealed packet was received and seals intact. The report further mentions that the packet was covered in white cloth and an opening in the packet. The examiner found a so and so. The seal being intact. The description of case number and the impression of the seal having been fixed on memo of recovery. There is no reason or justification to discard the prosecution case on the ground of delay on this court. In so and so, two judgments while dealing with the question of delay in so and so. Apparently, it was no consequence for the fact that recovery of the said sample of the possession of the appellant had been proven and established by cogent and reliable evidence, and that apart, it had also come in evidence that till the date of parcels of sample was received by that chemical examiner, the seal put on that parcel was intact. In paragraph 40, in view of the above analysis, we do not perceive any substance in this appeal. Accordingly, the same is dismissed. So my reply to that is that with the same case, in the same sample that was drawn before the JMFC was received by the FSL intact. It was sealed in wax seal.
No, FSL received it in sealed condition, but where is the evidence regarding putting up that seal there? That it was sealed in the presence of the magistrate? Has anything come?
Yes, Your Lordship. May I take Your Lordship kind attention to Your Lordship, unfortunately, Your Lordship, the case IO expired and she was not examined. Only the seizing officer.
No, it was the seizing officer who must have who took it to.
Yes, no, Your
magistrate.
Lordship. The case IO. Application was made by the case IO, Your Lordship, for inventory.
Zoramoi.
Yes.
Eh?
Zoramwani, yes. Zoramwani. And she expired, so she cannot be examined, Your Lordship. And the untimely demise of the case IO is stated before the learned trial court by the seizing officer in page number 6, para number 6 in his examination in chief. Your Lordship, list of sample drones, page 49. May I take Your Lordship kind attention to page? Certified list of sample, 49. Page 49. The case number and all is indicated in the first paragraph and second paragraph. Certified that the seized articles brought before me with seals intact from which of the following are drawn and packed in my presence. Drawn and packed in my presence.
Yes.
Yes, that is all my reply, Your Lordship.
Yes, anything in rebuttal?
If I may be allowed to make some more submissions, to rebut some of her submissions, the reference submissions. Firstly, with relation to the seal of the JMFC, the seal of the, before the samples were examined, it is submitted that the JMFC in his examination at page 7 of the paper book is completely silent on the question of whether the seized articles or the samples were being sealed. And what had been mentioned at page 49, which one was it? 49, list of sample drawn. Certified that the seized articles brought before me with seals intact. Seals were initially intact, from which the following samples are drawn and packed in my presence. They were drawn and packed in his presence, but there was no mention of any other seal being put after the samples were packed. So this also raises doubt again. And even if it is to be surmised that the samples were sealed before sending it to the FSL, there is no concrete proof that they were sealed in the presence of the magistrate and that they were not tampered with. In this regard, Your Lordship, and one more thing is with regard to the standing orders. In the case of Naveen Kumar, which I have also a copy of here, it has been mentioned that amongst many other grounds, non-compliance of the standing orders. Naveen Kumar. Amongst other grounds, it has been mentioned at page 16 of the judgment by the Guwahati High Court that one of the grounds for acquittal of the accused at page 41, page 16, paragraph 48, sub number 3 is that non-compliance of Standing Order 1 of 89. Paragraph 48, sub number 3, page 16. The appellants get the benefit of doubt because of the reasons enumerated herein below. 1, 2, and 3 is the one of the grounds for non-compliance with the standing orders. Standing Order 1 of 89. And as I have stated, Your Lordship, there has been no proof regarding the storage of the seized articles as well as the samples, such as Malkhana or go down receipt or anything of that sort. So the storage of the seized articles as well as that of the samples, and with the late submission of the samples, has raised considerable doubt on the case of the prosecution. And if I may bring Your Lordship's attention once again to the case of Alamo Latho, which was referred to earlier, at para 12, if I may read, Your Lordship. As stated earlier, the seized contraband were produced before CGM only on 16/8/2006. The prosecution has to explain how it could produce after a gap of 2 days. That is not relevant. The prosecution has to explain where and how the seized contraband articles were kept after being seized on 13/8/2006 at 3:30 p.m. till
You are referring to which one, Hanif?
Alamo Latho, which I have marked in the top of the page. At page number 307.
This one, Alano.
Alamo, yes.
Page? Para?
Page 308, 307, para 12. If I may read, Your Lordship. As stated earlier, the seized contraband were produced before the CGM only on so and so. The prosecution has to explain how it could be produced after a gap of 2 days. The prosecution has to explain where and how the seized contraband articles were kept after being seized on so and so till their production before CJM, where the contraband kept on the night of so and so, whole day and night of so and so till production on so and so before the magistrate. Were they kept in the personal custody of OC or in the Malkhana? The OC was also IO of the case. In his deposition, made no statement as to how and where those and whose custody the seized contraband were kept. So in this case, there is a serious doubt regarding the storage of the Malkhana, and it was for these reasons that the accused was acquitted in this case also. So if the same benefit may be given to the appellant in this instant case. And Your Lordship, if I may make one last submission.
Yes.
Yes, one last submission is that even if one aspect is assumed to be proved in this case, such as the possession and recovery of the seized contraband substances, but the case, as stated in Hanif Khan, is that it provides for a stricter compliance with all the procedures, and it is for the prosecution to prove the entire case, not only one aspect, the entire case beyond a reasonable doubt. And as far as my knowledge is concerned, Your Lordship, the prosecution has failed to do so in this instant case, such as the storage and the sampling and all those small aspects. It is only one or two aspects which has been proven and not the entirety of the case beyond a reasonable doubt. So when some doubt exists, the benefit should be in favor of the appellant accused.
All right, that is all. All right, CAV.
Obliged.
You can give them. This is ours. How big is this? You do one thing. You just do a photocopy of this page because I have noted down the keys otherwise.
This page.
Otherwise it will be unnecessarily bulky for us. But nobody wants to do any other cases. No.